Good afternoon. This is the House Judiciary Committee. It is February the 5th, a little after 2:30, and we're going to start with Delegate Roberson's bill now, House Bill 388. We have several bills, and David Daggett is virtual. All right, and he's coming on virtually. So Delegate, please go ahead with House Bill 388.
Thank you, Mr. Chair. Good to see you again, Madam Vice Chair. Good to see you as well. And to the hardest working committee in the Maryland General Assembly, the Judiciary Committee. It's good to see you all, colleagues, once again. I will note that Ways and Means does not have windows, so you are blessed in that you can actually see and feel the wind when the doors open. Today, we're here to talk about when the windows open. HB 388, it is a simple fix. You all passed it last year unanimously. Even Grammar voted for it, and so we are grateful to have it before you once again. But of course, we know how our colleagues in the Senate work, and sometimes they don't get the memo. And so we are hopeful that you will pass this once again. Just a brief reminder that the legislation seeks to fix an error in the Maryland Transportation Article Section 21-902. In 2019, legislation changed the penalties for DWIs and DUIs by increasing the penalties but not addressing the points penalties for drivers. The MVA became aware that although the penalties have increased, the point system was not included in the legislation. They currently do not, MVA that is, does not believe they have the authority to assess points unless written in statute. So therefore, I am here asking that we pass this bill to assess repeat DUI and DWI offenders, that they would receive 12 points when they are repetitive, which is the maximum number of points that can be assessed to any driver. I will note that the Maryland State's Attorneys Association, they might have provided a written testimony. They have previously on the need for this bill, and there should hopefully be no opposition. Thank you, Mr. Chair and Judiciary Committee, for your time.
All right. Mr. Daggett, if you'd like for 2 minutes, please.
Thank you very much, Mr. Chair and members of the committee. My name is David Daggett. I'm with the Maryland State's Attorneys Association. I've been a prosecutor for a long time, and for the last 13 or so years specializing in traffic, serious traffic charges across the state. I can't say it any better than I guess the delegate just did, and I appreciate him bringing this to your attention. It did come forward last year, and it does address a loophole. There was the multiple offenders, the third and fourth offenders for impaired driving. At this point, if they get convicted for those offenses that carry significant jail time, they don't have any points that go along with it. You can get a first or assuming you don't get a probation before judgment, a first offender or a second offender would get 8 or 12 points or whatever it might be for their offense. But a third and fourth offender convicted under this section that was passed a few years ago gets no points. So I think it does fill a loophole. I know MVA's hands are tied. And again, I appreciate the delegate bringing it forward, and we would ask for a favorable report on this particular bill.
Are there any questions? All right, that was easy. Thank you very much. That concludes the testimony for House Bill 388. We'll go now to the Vice Chair's bill, House Bill 438. And if I talk somewhat slowly, oh, you did? No, you can talk to him. He's in your district. You were going to give him a hard time because he's in your district. That's all right. Run. You're fine. You're right. You'll see him again. Delegate Bartlett as the Vice Chair.
Thank you, Smith.
Thank you. So you have Sandy Pop. Okay, that's fine. I have a virtual person, Kimberly Fullerton. Right? Okay, that's fine. Madam Vice Chair, go ahead.
Thank you, Mr. Chair, and thank you, members of the committee. It is my pleasure to present to you House Bill 438. For the record, I'm Sandy Bartlett from Anne Arundel County, and I come before you today to present House Bill 438, previously known as Buddy's Law. House Bill 438 changes the maximum dollar amount a plaintiff may receive for compensatory damages when their pet is seriously injured by the hands of another or death ensues. We have not increased the maximum available since 2017, and at that time, we raised it to $10,000. So it currently stands at $10,000. This bill, we seek to raise it to $25,000. And the reason for that is because emergency veterinary costs vary widely based on location, the type of animal, the type of emergency, what is needed, how many tests are needed. A trip to the emergency vet could cost more and does cost more than a regular veterinarian because of those many factors. One is because the facility is open 24/7 and they have to pay their staff to work around the clock. And so they're usually paid more than a regular vet who only practices during daytime hours. And these individuals have particular advanced training and skills, and they also have to have certain diagnostic and treatment specialists nearby or within the facility. These costs are then passed on to the client. House Bill 438 does not guarantee that pet owners will receive $25,000. It's up to $25,000. The claim for compensatory damages still must be substantiated and the same as any other civil case. So we raise the amount with this bill awarded to pet owners who can prove that the injuries to their pet were caused by another person or an animal under another person's control, and that the injuries sustained by their pet resulted in substantial veterinary bills or the loss of their pet. For these reasons, I urge a favorable vote. Thank you very much. Would you like to go next, Mr. Sure. Okay.
Good afternoon. I'd like to thank everybody for being here today. My name is Lawrence Sanders, and Buddy was our dog who was shot by a neighbor on June 20th, 2018. I spent over $15,000, and Buddy still died in my arms, and I made him a promise that I would get changes made, because at that time, pets are listed as property. And the police could pretty much do nothing, because if they knocked on the person's door who we knew did it, didn't have to answer the door, didn't have to be interrogated, didn't have to do anything. This bill, a similar bill, was passed, I think, either last year or the year before, but it didn't get 2 seconds in the Senate. There is a Senate bill this year as well. I urge you guys to pass this so we can bring protection to other families. It will do nothing for me. Thank you.
Good afternoon, Mr. Chair and members of the House Judiciary Committee. My name is Sandy Pop, and I'm here in my personal capacity to support House Bill 438. This past summer, my dog Andy was the victim of veterinary malpractice. I've included his story in my written remarks, but will highlight a few points. In August, I took Andy to a veterinary emergency clinic, and it was determined Andy had a foreign body in his abdomen and needed surgery. Post-surgery, Andy developed a fever and diarrhea. He was discharged 36 hours post-surgery with a bandage covering his incision. The next day, I took Andy back to the vet clinic. He was lethargic and his bandage was leaking. He was diagnosed with an infection, readmitted, and eventually given antibiotics. The next day, the clinic discharged him despite documenting that his infection worsened and despite my concern. I noticed there was a hole in his skin next to the incision site, and the clinic said that it was fine. I knew something was wrong. I took him to another emergency veterinary clinic where they transferred him to surgical specialists for revision surgery. The surgeon told me that if I had waited another day, Andy would have been on death's doorstep. The infection was so bad they had to remove his falciform, and he had to remain in their ICU for 4 days after the surgery. There were a lot of failures at multiple points at the first emergency veterinary clinic. I tried to find an attorney that practiced in this area and was told by one attorney, the damages you can get in Maryland are very limited and the cost of pursuing the case will generally outweigh the recovery. For that reason, my husband sent a demand letter to the emergency veterinary clinic that caused the injury, alleging negligence and seeking compensatory damages in excess of $23,000 to cover the cost of Andy's veterinary bills. Their malpractice insurance company offered us $10,000 minus taxes. They refused to negotiate above Maryland's cap, which meant that the first veterinary clinic would still receive payment from us for causing the injury. I strongly believe Maryland's cap on compensatory damages should be increased to better reflect the actual costs of reasonable and necessary veterinary costs, and that it is important to allow pet owners a chance to be made monetarily whole if faced with a similar situation. I also find Maryland's $10,000 cap on damages to be an outlier compared to its neighboring jurisdictions, as noted in my written testimony. Thank you for allowing me the opportunity to testify. I respectfully request a favorable report on House Bill 438. Thank you.
Good afternoon, Mr. Chairman, members of the committee. My name is Patrice Meredith Clark. I'm a trial lawyer testifying on behalf of the Maryland Association for Justice, and we respectfully request a favorable report on House Bill 438. This is a simple, common sense bill. In Maryland, as you heard, pets are regarded as property. In Maryland, if someone negligently damages or destroys your property, then you can file a lawsuit and seek to recover the amount that it takes to repair or replace that property. There's no limit on the amount that can be recovered for damage or destruction of property, and that makes sense, right? I like to think of it this way. The cost to repair or replace a 2015 Toyota Corolla, which is a great car, is going to be a lot less than the cost that it takes to repair or replace a 2025 Audi A6, right? So we rely on juries to review the evidence and determine the actual value of the property damage based on what they hear in any particular case. If a distracted driver accidentally swerves onto a sidewalk and hits my dog that I'm walking on a leash and it costs $23,000 for me to get care for that dog, I can still only recover $10,000. Respectfully, it makes no sense to limit the amount that we can recover to repair or replace a dog when we don't limit the amount that we can recover to repair or replace a car. Any cap on the amount that can be recovered for property damage is arbitrary necessarily, and in our opinion should be repealed. But at the very least, the cap should be increased to account for inflation and the reality of very expensive veterinary bills. We urge a favorable report. Thank you very much for your time.
Ms. Fullerton, please.
Good afternoon. My name is Professor Kim Fullerton. I am here on behalf of the Maryland State Bar Association's Animal Law section, and I also teach animal law at the law school. But today I just have my MSBA hat on. And I want to follow up on the previous remarks about how animals are property in the state of Maryland. And an anomaly within our laws as they exist currently. So pets are the only type of property in Maryland that has this cap. And Judge Hutton wrote a really wonderful opinion demonstrating how, say we have someone that has a seeing eye dog next to $1 million painting of their seeing eye dog. If someone comes up and shoots both, maliciously, intentionally, they're going to recover $1 million for their painting of the dog, but they're capped at $10,000 for the dog itself, which is just a drop in the bucket compared to what you actually pay to purchase the dog and then training as well. So within Maryland, the second anomaly is that our criminal law is not in alignment with our civil law. So the way that our civil law works now, we have that $10,000 cap. But if a prosecutor brought that case based on the same set of facts, there's no cap on what you can recover when you prove actual damages. And we even can pay those expenses out of our Maryland Victims Fund. So I'm not quite sure why in Maryland we have this cap. Why aren't we holding the people that are intentionally killing and harming animals responsible? Why are we protecting someone in this situation? I also want to note that this is just compensatory damages. It is not non-economic. So these are going to be expenses that you go in with a receipt, you show the judge, and the judge makes a decision. Is this reasonable? Was this necessary? I also want to note that Maryland is a contributory negligence state. So if you are 1% responsible for your accident, for this event, you're not going to recover. This is not going to be something that allows any kind of economic recovery. Thank you.
Questions for the panel? Delegate Kaufman.
Yes, this is a question for the sponsor. I'm putting, the American Property Casualty Insurance Company has their usual mantra, if you will, about how they are concerned that the bill could increase litigation costs and lead to rescissions of insurance coverage or not offering insurance or skyrocketing rates, and therefore they say only increase it to 15,000. And so I wanted to know, number one, what you thought of their amendment, and secondly, in other states that don't have the veterinary cap, have you seen skyrocketing insurance rates or people not offering coverage? And lastly, I just want to say, Ms. Pop, it's nice to see you on this side of the street. I'm sorry for the reason, though.
Thank you, Delegate Kaufman. And if you don't mind, I'm going to let my two experts answer those questions because I think they, I know that they have a good answer for you.
That's fine. Thank you.
I'm happy to chime in. It's important to note that this 25,000, that's still within the threshold for district court. So I just don't find it believable that this is going to trigger a landslide of litigation. You're still in district court. This is not going to apply to a jury trial. It's just a judge, district court. And again, if there's any contribution to the accident, that case is not going to go forward. You're going to be barred from recovery. And to your point about what other states, if they've experienced a dramatic increase or loss of coverage, not that I'm aware of.
The only thing I would add, Delegate, is that I poked around a little bit to try and figure out that exact question, whether there have been skyrocketing insurance rates in states where there's no cap or where there's a higher cap on damages to pet, and I couldn't find any of that information. I couldn't find anything to support that claim.
Okay, if you do, please send it to us. But thank you, Mr. Chair.
All right, seeing no further questions, we thank this panel very much. There's one person signed up to testify favorable with amendments, and that's Lawrence Sanders, but that was you, right?
Yeah.
All right, so just to be clear, you're favorable on the bill. All right, thank you very much. That will conclude the hearing on House Bill 435, 438, and now we're going to House Bill 310, two bills, Delegate Cardin, coming up. House Bill 310, if we could have Thomas Grace and Bob Enton come up. Delegate Cardin for 3 minutes, everybody else for 2.
Thank you very much, Mr. Chair, members of the committee. John Cardin on behalf of House Bill 310, asking for a favorable report. This was brought to me by the State Bar again, and I hope that it will be received favorably. This bill establishes under Title 15 of the Estates in a Trust article that unless waived by the client, that there is an attorney-client privilege or there's a privilege for fiduciaries. And this would be separate, but not completely divorced from the attorney-client privilege that already exists. And I certainly will have my experts explain why, but the fact is that when you are talking to a fiduciary, you want to make sure that what you're saying, because there could be some sensitive issues, are going to remain confidential if necessary. I'll stop there. I can go into more detail, but I think that the witnesses will be able to explain it eloquently.
Thank you, Chair, Vice Chair, members of the committee. My name's Tommy Grace. I'm a Trust and Estates attorney practicing in Maryland, testifying in support of House Bill 310 on behalf of the Estates and Trust section of the Maryland Bar. The attorney-client privilege is an established statutory principle allowing clients and their attorneys to communicate openly and confidentially with one another without fear or concern that their communications may be discovered in litigation and used against them. Maryland has very limited exceptions to the attorney-client privilege. For example, an attorney cannot give legal advice in furtherance of a crime without communications being privileged. Fiduciary here means, for example, the trustee of a trust or the personal representative of an estate. And fiduciary exception here would mean that if a trustee of a trust or a personal representative of a state, for example, hired an attorney to talk about matters, that those communications would be at the risk of being discoverable and not being privileged. There is uncertainty in Maryland whether a fiduciary exception to the attorney-client privilege exists. Minority of jurisdictions have taken the position that advice between an attorney and a fiduciary is discoverable because it relates to beneficiaries and beneficiaries may have rights to that information. Maryland, however, has not recognized a fiduciary exception to the privilege, and we would respectfully like to affirmatively codify that no such exception exists. A fiduciary, just like any other client seeking legal advice, should be entitled to have their communications with counsel be privileged. As a real-world example, I represent a trustee who, within the past month, was approached by a beneficiary for a large distribution from a trust. And the trustee and I have had pretty candid conversations about the ramifications of that request, like what would the tax consequences be? What is the risk of, being sued by the remainder beneficiary? And our communications would not be so candid were that at risk of being discoverable. So we respectfully request approval of House Bill 310. Thank you.
Thank you very much, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. Banks act as fiduciaries. They have historically, and they still do it today. If you think back in the old days, a lot of banks were like in Baltimore, Equitable Trust Bank, Mercantile Safe Deposit and Trust Company. And they hold these assets, and it's, as someone who's been practicing law for a very, very long time, it would be inconceivable to me, frankly, and I think this bill is needed for clarification, that these communications would not be privileged. So we fully support the bill. Thank you.
Delegate Eric.
Thank you, Mr. Chair. Thank you guys for being here. I have a quick question. I'm sure you can assuage my fears. So sometimes you'll have a fiduciary, but you'll have more than one client. What happens in a scenario where one client feels there's been some misuse of funds and they want to litigate, but the other client is refusing to waive their confidentiality?
So she means beneficiary, that client.
So yeah, to clarify, if I'm the lawyer, the client is the trustee, or there are multiple trustees that disagree?
Correct. So we have one person who's in charge of making the decisions on the money. We have a bunch of people who are sort of getting funds distributed to them.
As beneficiaries.
Right. What if one of them doesn't want to waive that attorney-client privilege, essentially, but the other one does because they believe this person has misappropriated some funds, or this person's benefiting in a way they think it's not in line with the trust?
So the attorney-client relationship would be between the trustee and the lawyer. Beneficiaries would not be part of that relationship.
Okay.
They could certainly, bring a suit against a trustee if they thought there was their breach of fiduciary duty, for example, but they wouldn't be part of the attorney-client relationship.
Okay, so they would be outside of that. So how would they get information in order to litigate? If it's now protected communication?
I mean, sure. I mean, they're certainly entitled to accountings and information about trust assets and information about, if they come with a request for, a distribution and that's honored or not honored, or if they ask a question about a particular investment that a trust makes, they're certainly entitled to answers to that, but they just wouldn't be entitled to the discussions between the trustee and the lawyer that go towards making a certain decision.
Interesting. Okay. I don't know if I would love that if I was beneficiary, but I can sort of see the point of it, but there's something there that's still kind of.
I'm going to, the estates and trust lawyer will correct me if I'm wrong, but I think this is already practice in Maryland.
They're already doing it, but it's just not.
It's just not codified. And there are jurisdictions out there, a minority of jurisdictions out there that have ruled that that information is discoverable. And I think Maryland Bar says we want to make sure that the way that we're practicing now is codified.
Okay, so there have been cases where the recipients have actually tried to get access to the communications, and then there's case law that says that they can?
There's case law in other jurisdictions that, the minority that say they can, but Maryland's not ruled. So it's an open question that we'd like to shut the door and say, preemptively say, communications between the fiduciary, again, trustee, personal representative, et cetera, and the lawyer are privileged and not an exception.
And I'll just reiterate what we talked about last week or 2 weeks ago. The fiduciaries, and I think it's defined actually in the fiscal note here if you want, fiduciaries are required by law to look out for the best interest of the beneficiaries and the trust.
Yeah.
So if they violate that, they obviously, it can be litigated and they can be sanctioned in various and sundry ways. But the fact is that a fiduciary who's trying to do the best job he can, should he be able to talk frankly with his attorney before, to make a decision on what is the best thing to do without worrying that that information could get into other people's hands, whether it be the beneficiaries or somebody else's. Is that correct?
Right, and to use the example I mentioned in my remarks, a trustee comes to me and says, I'm a trustee, the primary beneficiary has requested half of the money. And, the trustee and I have talked about, well, what is her financial wherewithal outside of the trust? What are the merits of the request? What might she do with the money? May he be sued by the next generation, for taking money out of the trust and skipping that person because the money could be spent. And for us to be able to have such candid conversations, we're relying on the fact that, well, the primary beneficiary and the remainder beneficiary happens to be her son, wouldn't have access to our emails and phone calls, et cetera. So for us to really fully vet the issue, we're relying on the fact that it's just going to be between me and the trustee.
Yeah, I hear you. I mean, yeah, I'll have to think about this one a little bit more, but I really appreciate your testimony.
So, and thank you for bringing this. Who is the client?
The fiduciary. So whether it's to continue with this example, but there's many, it's the trustee of the trust here.
So if the trustee of the trust is the client, then the attorney-client privilege goes to the client, correct?
Right, between my communications with the trustee or the personal representative or whoever the fiduciary is in the situation, that's right.
So I'm trying to figure out why the court, any court, would not honor the relationship between the trustee
Great question.
and the attorney.
That's exactly the point.
Yeah.
That's exactly the point, Delegate,
So,
is that.
so I'm trying to figure, why do we actually need to pass legislation for that? That's kind of accepted.
I mean, it's we'd like to codify it and just alleviate any gray area and just, settle the issue once and for all.
There are jurisdictions not in the state of Maryland that have ruled that there are rights of, for example, a beneficiary to be able to access information that these two parties thought was privileged.
Okay.
And so Maryland doesn't want to get caught up in a judge who may look at that and say, oh yeah, that beneficiary maybe does. And so the question is, can we make sure that this is codified? That's the essence of the bill.
Anyone else? Seeing none, thank you very much. That'll conclude the testimony on House Bill 310. Go to House Bill 315 now. This time, different witnesses. Jonathan Lastly, well, they're all favorable with amendments, so that's fine.
It's fine.
Jonathan Lastly, Elizabeth Fitch, and then virtually Byron McFarland. All right?
Thank you, Mr. Chair, members of the committee. John Carden on behalf of House Bill 315, asking for a favorable report. This is it's something that our chair loves so much. It's a task force. This bill, please don't put it in the blue file cabinet yet. This bill establishes a task force to study fiduciary adjudication in Maryland. The governor designates the chair, and then there are other appointees. But for all intents and purposes, it's to examine the qualifications, training, and methods and selection of judges who hear issues on probate, on fiduciary matters, so that we can see whether we need to better train and better understand how to handle fiduciary matters, so we don't run into the problems like the last bill where there are issues of people not functioning properly as fiduciaries. That's the essence of the bill, and I'll leave it up to my witnesses to to eloquently explain it.
This is my first time here, so I'll go last.
Okay, all right. So a couple of years ago, Jonathan Lastly, on behalf of the Estate and Trust Law Section of the Maryland State Bar Association. Thank you, Mr. Chair, members of the committee. A couple of years ago, there was a task force to look at the orphans courts, but it was limited to the orphans courts. And they came up with a few proposals to sort of nibble around the edges of some issues that we see. But it became apparent as we looked at the solutions they proposed that there are a number of areas of overlap with how different fiduciary matters are adjudicated. So for example, if you have a will and a revocable trust in your estate plan, any assets passing under the will are the subject to the orphans court as part of the probate estate. Any assets passing under the revocable trust are subject to the circuit court jurisdiction. So if you have a matter that affects both, you've got to go through a whole rigmarole of starting in the orphans court, getting it over to the circuit court, and getting them consolidated. In addition, there are a number of different qualifications for orphans court judges around the state. Some jurisdictions have lay judges. Some jurisdictions have circuit court judges serving in that capacity. And so depending on those results, you may end up trying the same case twice. So anyway, we've come up with this task force to look at the issue as a whole, to build on the work of the prior task force. We've proposed amendments that make all the different interest groups equal in how they are treated in this, and those are in front of you. There is one typo. It should say TWO registers of wills, not TO registers of wills. My bad. So with those amendments, we urge a favorable report.
Good afternoon. My name's Elizabeth Fitch. I'm a partner at the law firm of Sims, Bowen & Sims in Baltimore, Maryland. In 2018, I was elected to the Orphans Court for Howard County, where I sat for 4 years. I was reelected in 2022 to serve another 4 years. Sadly, that same year, my court was abolished. My practice now is focused exclusively on trusts and estates. I see everyone's eyes glazing over, emails being checked, like what the heck is fiduciary adjudication, right? Who are these people? This is all about money. So if you like money, you would like, this task force. Where do we adjudicate fiduciary? Where do we fight about money right now? In the federal court. If we have a life insurance policy that is being interplayed by the policy, the bank. In the circuit court, where we litigate trust. In the orphans court, where we can litigate wills, but we can also litigate wills in the circuit court. In some jurisdictions, you can appeal from the orphans court to the circuit court. In other jurisdictions, you appeal from the orphans court to whatever our intermediary appellate court is named now. So we don't really, a lot of people don't love the name Orphans Court. I think that the issues that we want to tackle are bigger than what do we call it. It is how do we streamline the system that we have? How do we move Maryland forward in a way that best serves the public so that these very intimate and very expensive disputes can be resolved as efficiently as possible. Mr. Lasley touched on the fact that some courts have circuit court judges sitting as probate. Some courts have lay judges sitting as probate, meaning they're not lawyers, they've never gone to law school. Other courts have attorney judges, but they are all part-time. Some courts are in business once a week, others one day a month. We're a little bit all over the place. So with that, I support this bill.
Byron McFarland, please, for 2 minutes.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. My name is Byron McFarland. I am the Register of Wills for Howard County, a member of the Rolls and Bar Committee of the Maryland Register of Wills Association, and I'm pleased to be here to support this bill. I won't reiterate too much of what Mr. Lasley and Ms. Fitch had to say, but just to reiterate that, all probate matters originate with the Registers of Wills. And we do see these kind of related matters, whether it's an accusation of some kind of wrongdoing that happened during the life of the decedent who was subject to a guardianship, something having to do with trust administration. There's been discussion about circuit courts and appellate courts. We also deal with issues like landlord-tenant issues, and orphans courts do not have the power to evict someone from the home of a decedent, even though some courts attempt to do that. So we do have all of these interrelated issues, and unfortunately, we do have a probate court that has the most limited jurisdiction of any kind of specialty probate court in the country. Most similar probate courts or orphans courts elsewhere do have jurisdiction over conservatorships, guardianships, trusts, but we don't. And so, as the originating kind of office, when probate matters are initiated, we deal with a lot of frustration from the public when we say, no, you have to go to circuit court for that, or you've got to talk to an attorney and go to district court for that. And there's a lot of overlap and confusion at a time when people are already dealing with a stressful situation. And so I am here just to thank Delegate Cardin and his Senate counterpart on this measure, Senator West, for their leadership, for our friends in the Bar Association and partners in government, and just say we are ready, willing, and eager to be part of a hopefully collaborative process to see, can we do better for the people that we all serve? So with that, I urge a favorable report with the amendments that Mr. Lasley referred to. Thank you.
Delegate Phillips.
Thank you. And Judge Fish, let me ask you, do you have a predisposition before we have a study?
No. Unlike some of my colleagues, I'm not a fan of abolishing the orphans court. I think there's something very special about it. It's referred to sometimes as the people's court. And as Mr. McFarland has pointed out, it's very accessible. The Register of Rules office is a public office that's open all day. People can go to them with their inquiries. The court proceedings are less formal, more approachable without an attorney. I wouldn't suggest that accessibility be changed. And I hope that the mission of the task force is not predetermined. I hope that everyone comes with an open mind. How can we do this better? Where are the inconsistencies? How do we make everything equitable across the state? Certainly Baltimore City and the Eastern Shore have different needs. How do we meet both of their needs?
And to the sponsor of the bill, I didn't get all of the details. What are we asking the task force? Do we have real clear directions for what we want the task force to do?
I can run through it if you want. It's
Please.
Just, examine the qualifications, training methods of judges, examine the jurisdiction of the orphans court and the circuit court with respect to fiduciary matters. So with all this, what's juxtaposed, what are they doing, and why are we separating it in the ways that we are, so that we can understand all the different interactions. And as the judge brought up, we also have a federal experience as well in some of those matters. Analyze efficiency of procedures and how to improve efficiency of procedures vis-a-vis orphans court versus circuit court. Analyze the effects of the different qualifications of orphan court judges related to litigation. So what the judge was just talking about in terms of
lay judges versus
circuit court judges versus lawyer judges. Seek guidance from appropriate witnesses. I'm just reading what the task force is tasked with doing. Analyze and compare laws and practices of other states. Examine, research, and analyze guidance related to the best practices for fiduciary matters.
Where do those recommendations go?
Where do they go? They go to,
after they're done.
It goes to the recommendations go to the governor and the General Assembly.
Okay.
I'm assuming, and then you can draft a bill.
No, you can draft it.
Delegate Sample Hughes.
Thank you, Mr. Chair. Thank you, Delegate Cardin, for the bill. I just wanted to ask you just a couple of things. In its current state now, does the orphans court and or circuit court show you how this is a problem? Meaning, I know your experience within it, like you were serving on the orphans court and you've seen where people are having to go between the orphans court and the circuit court, and you want to provide some level of efficiency in that process. Is there tracking of that? Is that how you were able to compile that this is such a huge issue? Anybody?
I mean, the bar should probably.
Okay, so we're working on developing that data to the extent it's available. It's tricky because some things, as Judge Fitch said, go on appeal. Some things also go de novo. So for instance, if you're heard in the orphans court, the matter might go to the circuit court for a whole new trial. So you get your training wheels in the orphans court, and then you go do the same thing and hopefully do it better in the circuit court. So tracking that data is tricky, but members of the bar who practice in this area run into these problems all the time, and I know that Judge Fitch saw it some in her own experience there. Back 270 odd years ago when the orphans courts were set up in their current form, property and wealth transmission was a lot simpler. Usually you just had a piece of land and that's where it went. Now we've got everything going from probate assets like a car and real property and bank accounts and things like that to non-probate assets like trusts and IRAs and 401ks and insurance policies and TOD accounts. And all of this goes together, and you're looking to different people to solve perhaps the same problem in different places. And so there are a number of good things with a system that's lasted 250, 270 years. And we want to make sure to preserve those, as the judge said. But at the same time, we need to look at where we are now and try to find solutions that work for everybody.
Sure, thank you for that response. Kind of like the delegate just asked, our delegate at the table, do you already have something in mind of where this should go? Meaning that you're anticipating that everything should start in the orphans court instead of circuit and vice versa? That's
Sorry.
Sure, that's one part of it. And then the last part, if we start to tinker with the responsibilities of the orphans court, then we're gonna be back here for a conversation about compensation. So I was just curious that might be one of the things that comes out of your task force if our chair allows it.
So the answer is, yeah, do we have thoughts on what would be improvements? Sure, but are they set in stone? Absolutely not.
Right.
And we also think that having a specialty court and specialty and local court is important in this process. And I'll say that much. But what that looks like is a different, is going to be up to the task force to determine. On the task force, we've asked that the governor's appointee have expertise in budget and personnel matters for precisely the reason you raised, that yes, it's going to have questions of how, depending on what direction this goes, there's going to be money involved.
Yeah, for sure. And that's one of the inconsistencies around the state is that the Register of Wills is, Mr. McFarland, he serves Howard County. He's paid by the state. When there was an orphans court in Howard County, we served Howard County, but we were paid by the county. All of the other judges in the state are paid by the state. There's judges that make as little as $8,000 a year. There's some that make, something in the neighborhood of six figures. And to illustrate, some of the need for the court, before I was a judge, I clerked for the court. At that time, there was no telephone, no copy machine, no fax, no scanner. There was one computer that was shared by 3 judges. We sat on a bench like this, and literally one judge had a computer and no one else did. We had one file for each and every estate. So if we wanted to see the file while we were presiding over a hearing, we had to go to the register and say, hey, could you make a copy of these specific docket entries for us so we can do our job? So funding and resources is if I'm dreaming, we would fully fund and fully equip the court. When we moved into the new courthouse, we did get computers. They were left over from the Board of Education. You can imagine, So we're trailing a little bit behind, and I appreciate everyone's time and attention. Delegate Clippinger, Delegate Cardin, thank you for giving this some attention. I appreciate it.
Yes, and I appreciate my colleagues' indulgence. My friend Google couldn't help me out with this. Oh, I'll wait till my mic's on. My friend Google couldn't help me out with this, so somebody used the word de novo. So for those of us that don't, if it says in Latin from the beginning, but I didn't know what that meant, and some of us don't speak a state law.
So when you start in one jurisdiction, let's say the orphans court, and you decide you didn't like the outcome, so you appeal it, or you try to move it to and appeal it to the higher court. Sometimes it's what's called on the record, which means that they take whatever was said and transcribed from that, and the evidence that might have been brought in from that hearing, and that's all that's going to be reviewed and be able to be used as evidence in the next trial. Or it could be de novo, which means that you start all over and you can bring in all new witnesses, bring in all new evidence. You can learn from your mistakes. This wasn't admitted by the judge. Therefore, let me figure out how to get it admitted. Let me talk, maybe, figure out if this isn't the right document because he told me this was the wrong document. So it's all de novo. It's brand new. You can start over from the beginning.
So an attorney gets to decide which course they want to take? Whether it's de novo or not?
In some jurisdictions, yes, because in some jurisdictions, you still have the option to appeal to the appellate court or to the circuit court. Circuit court, you go de novo, meaning you start from scratch, you do everything all over again. The appellate court, meaning you're appealing just a legal issue.
Okay.
It's more of a legal exercise.
Okay.
It's not a whole new trial.
Thank you for your indulgence, everyone, as Montgomery County doesn't have an orphans court, so thanks.
You do have an orphans court. Your circuit court judge just presides over it.
Yeah, but they're judges, right?
Right, well,
All good.
Are there further questions for this panel? All right. Seeing none, thank you all very much.
Thank you all.
Thank you.
That concludes the testimony on House Bill 315. We now have several bills from Delegate Grammer, starting with House Bill 336. And go ahead and call up, okay. Shanitha Lewis, okay. And Holland Brownlee. Okay, that's fine. So we'll go from there.
Thank you, Mr. Chair. None of these bills are interesting as task forces on to study fiduciary adjudication, but they're riveting nonetheless. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer here to present House Bill 336. House Bill 336 protects the firearm ownership rights of those who qualify to use medical cannabis by reconciling the public safety and health articles. A loophole continues to exist between the laws governing our medical cannabis industry and the laws governing our state police. Currently, patients who qualify to use medical cannabis, a legal product through Maryland's legal medical cannabis certification, lose their rights for answering the relevant firearms forms. If you have a card or even a simple administration issued identification number, you lose your rights. You need not purchase, possess, or use cannabis. Your status as a qualifying patient, per the current procedures followed by the state police, prohibits a legitimate purchase. When asked for an opinion, Attorney General Brian Frosch wrote that state law does not permit the state police to deny applications for purchase, handgun qualifications, or carry permits. He recommended that to clarify this issue, the legislature should reconcile the public safety article with the health general article, section 133313, and that's what this bill does. In a previous year, combat veteran Josh O'Neill testified in support of this bill in 2019 that he carries a firearm as part of his employment and would like to use cannabis for pain management due to a combat-related injury. Ironically, he works for the medical cannabis industry. He described his addiction to pain pills for 2 years and his recovery. I'm in horrible pain every day. I sleep about 2.5 hours every night. I just want to sleep. Hunter Biden's case was supposed to resolve this issue. He received a pardon. Maryland qualifying patients need protection, and we need to provide the leadership to protect them. It makes no sense if qualifying patients in Maryland cannot legally purchase a gun, but can legally carry one. We should pass House Bill 336 to protect the rights of those who use non-addictive medical solutions. I'm happy to take questions, and I would ask for a favorable report.
Thank you. So good afternoon. My name is Shanitha Lewis. I'm the Executive Director of Veterans Initiative 22. It is a nonprofit organization whose mission is veteran suicide prevention through affordable and safe access to medical cannabis. Not sure if I should admit this now, but I am also on the Governor's Task Force for the responsible use of natural psychedelic substances. As a veteran, I took an oath to support and defend the Constitution of the United States, including the fundamental right to bear arms. Many of my fellow service members and I have returned home with injuries, both visible and invisible, that require ongoing medical treatment. For some of us, traditional pharmaceuticals, including opioids and antidepressants, have proven to be either ineffective or riddled with debilitating side effects. Medical cannabis has provided a safe, effective alternative for managing these conditions, such as chronic pain and other conditions that disproportionately affect veterans. When I speak to veterans who consume cannabis for medicinal purposes about our organization and services we provide, the most common reason that vets cite for not obtaining their medical cannabis certification is that they refuse to lose their constitutional right to bear arms. It is not only a travesty, but also quite hypocritical that the very population our government has meticulously trained to be responsible firearm owners is now told that the legal medicine that they use to treat service-related injuries disqualifies them from owning or possessing a firearm. Despite the fact that medical cannabis is legal in many states and prescribed by thousands of licensed healthcare professionals, veterans who choose this treatment option are unfairly stripped of their right to own a firearm. This policy is both outdated and discriminatory, punishing law-abiding citizens for seeking a legitimate medical treatment that improves their quality of life. I urge lawmakers to pass HB 0336 and begin to work toward a solution that upholds the rights of responsible, law-abiding veterans in Maryland who use medical cannabis as part of their health care. Veterans should not have to sacrifice one constitutional right to exercise another. Cannabis is medicine. We urge a favorable report on HB 0336. Thank you.
Thank you. Ms. Brownlee?
Thank you. Good afternoon, Chairman Clippinger and members of the committee. My name is Holly Brownlee, and I am an Assistant Public Defender in District 3, Talbot County on the Eastern Shore. The Maryland Office of the Public Defender respectfully requests that the committee issue a favorable report on this bill. As the law stands right now, any Marylander who wishes to purchase a firearm must certify on the firearms forms that all Marylanders would use that they are not a medical cannabis patient or habitually use cannabis and potentially face criminal penalties if they lie about it. This bill would clarify that Marylanders cannot be denied by the Maryland State Police from possessing or purchasing a firearm simply because they use medical cannabis. Cannabis is the only medical prescription that I'm aware of which is currently treated this way by the state of Maryland. This bill is therefore an important step in the movement to decriminalize cannabis and reduce the number of people in criminal legal jeopardy for possessing and using cannabis. As the others have said, the Office of the Public Defender firmly believes that Marylanders should not have to choose between exercising their legal right to possess firearms and accessing their medication, and we urge the committee to issue a favorable report on this bill.
Thank you. Are there any questions? Delegate Valentine.
Thank you, Madam Chair. I do have one question. Thank you, Delegate, and thank you, panel. Last year, I see that this was brought last year. Could you kind of elaborate on, and I see you've done quite a bit of work on this, Delegate, what transpired with last year's legislation?
Yeah, so as happened in the previous few years, the bill passed the Senate unanimously, and the decision rested here in this committee. I was advised to work the bill. We needed to go around and talk to the folks who had a real concern about the issue in the broader House and deal with those concerns when that was done. And then the issue, strangely enough, of Hunter Biden came up. Here was the charge, illegal possession of a firearm due to drug possession. And Hunter Biden challenged that on constitutional grounds, and we were advised we need to kind of wait for that case to play out to see what the courts were going to decide on this issue. Ironically, he received a pardon, so that case is mute at this point. So the ball is back in our court here. The Senate continues to be fine with the issue, and we're waiting for this committee to take some kind of position to protect these folks.
Thank you. Thank you, Madam Chair.
Sure. Delegate Phillips.
Yes, to the Office of the Public Defender, if I am a user of cannabis that is not considered habitual, I sign my form, I'm able to purchase a firearm, is that correct?
I believe this bill would only cover medical cannabis patients. So it's,
Right,
it's
but
not
I'm
there
saying,
yet.
and maybe that's to Delegate Grammer, right? If I filled out the form and I said, no, I'm not a habitual user, and no, I'm not a medical user, but I do use, would I be restricted?
I think the answer to your question is yes. And I believe that it would the ultimate response to that is, how does the federal government define the word habitual? Habitual. But I think for the adult case scenario, that person's okay. What we're trying to protect the folks that have a card.
And the reason I bring that up is because I'm trying to figure out how do you parse out one group, right?
Yep.
And not the other.
It's the question. If you read the form, and I'm happy to show you the form, but you have to answer the form honestly.
I understand.
And the form allows for the folks who use but do not use habitually, they can answer it honestly. But the form literally asks, do you have a card? And you can't get around that. Unless you take what Attorney General Frosch has advised, and don't tell anybody, but this is Attorney General Frosch's bill. Per his opinion, his formal opinion, we have to reconcile these articles, and that fixes our problem. So for those particular folks, this is the solution we have to get across the finish line. Frankly, for these people, these qualifying patients, they could get raided, they can have their possessions taken. We really just want to give those folks protection.
If we were to pass this bill, but there would be some not in sync with the federal law, what happens to the individuals?
I actually don't agree with that, and that's the great question. That's the whole point of this issue. I'll give you Attorney General Frosch's letter, but what it essentially says is our relationship with the federal government is a voluntary one, and that is what allows us to make decisions about our state program. We would be in sync and, frankly, acting voluntarily as the federal point of contact, but acting in a way where we handle the administration of our own programs. We do it with carry licenses. It's the ultimate irony. If I have a gun, I can get a carry permit and still be a qualifying patient. I can carry the gun. I just can't buy one. It's ridiculous.
Thank you.
Thank you.
Thank you. Seeing no further questions. Thank you so much. That concludes our testimony for House Bill 336. Right, Delegate Grammer, you're going to be there a little bit.
Just a couple minutes.
Yes, so we have testimony to begin for House Bill 354. Delegate Grammer. And yes, Mr. Pinnock, you can.
I was scheduled to testify on 336.
On 336? You most certainly are scheduled as information only? Come on down. Thank you. It's color-coded and everything, and I still missed it. I apologize.
Not at all.
Thank you, Madam Chair. My name is Mark Pennock. I'm the president of Maryland Show Issue. I'm an attorney with many years of federal experience before retiring. The issue before the committee is not really a matter of state law because federal law is controlling. You cannot buy any firearm in the state of Maryland or anywhere else in the United States without filling out a Form 4473, which is a federal form. And on that form, it says if you are a medical marijuana user, you are prohibited from purchasing this firearm that you're attempting to buy. Full stop, right there. Because medical marijuana is still a prohibited substance under federal law. It is a felony to possess medical marijuana under federal law. It is a felony to be any user at all, not merely an habitual user, any user at all, that of medical marijuana or any other medical marijuana and possess a firearm. It is a 10-year federal felony to do so. Now, I'm very sympathetic to the aims of this legislation, and I've told Delegate Grammer many times about that, and I'm very sympathetic with the needs of veterans. But what I don't want to have happen is people spending a lot of money and a lot of time and a lot of effort to get these licenses, including a handgun qualification license and a carry permit, only to be arrested by federal agents because they're carrying a firearm while being a medical marijuana user. That's the risk of this legislation. Now, in my written testimony, I've laid out page after page of case law and statutory law and regulatory citations that establish this beyond any reasonable doubt. But I'm happy to take questions on it.
Delegate Phillips.
Thank you. And I know you are the scholar as it relates to our issues when it comes to carrying or possessing. Are there any other states that you're aware of where so we have a form. Do we use the exact same form as the feds, or have we modified our form here in the state of Maryland?
No, in Maryland, there are two forms. One is the federal form, which is 4473, and then there's a state form, Form 77R. So any purchaser of a regulated firearm, handgun, has to fill out both. Any purchaser of a long gun simply fills out the Form 4473. But you have to do both for any handgun at all. So the state polices use both forms to do the required background checks. So the background check goes to the FBI, for example, for the 4473, they do a background check under 18 U.S.C. 922T. So if the FBI reports this person is a medical marijuana user or have any information, that person will be disqualified. But even if the sale goes through, that person, if he lies on 4473, that's a felony. That's a A6 felony under Section 922. That's a 10-year felony. So if he continues to possess a firearm after that point, he's a felon, a medical marijuana user in possession. That's a 922G3 violation, and that's a 10-year federal felony. And there's no two ways around that. That's the problem.
So let me go to that second question. Have any other states tried to do this?
Not to my knowledge.
Okay, thank you.
Sure.
Thank you, Mr. Pinnock.
Thank you.
Now that concludes our testimony for House Bill 336. We're going to move on now to House Bill 354.
I'll start when you're ready.
Okay, and do you want to have some folks come up with you?
Absolutely.
Okay.
Whoever's favorable.
Whoever's left for favorable, yes? Okay, so we want John Jocelyn, we want Mr. Pinnock, and we'll keep Ms. Brownlee on virtual, so we're good. And Delegate Grammer, whenever you're ready to start.
Thank you, Madam Chair. We're going to tackle this bill a different way this time. For the record, Delegate Robin Grammer here to present House Bill 354. House Bill 354 modifies the culpability standards for illegal possession of a firearm. Over the interim, myself and other members of the legislature visited the Charles Hickey School. The detention center houses male youth, both those charged as juveniles and those charged as adults. The staff articulated the offenses for which the juveniles were held, and we found one set of numbers to be quite shocking. For male youth charged as adults, more than 50% of those detained at the facility were being held for one single criminal charge, the illegal possession of a firearm. When I asked how that happened, the staff stated, the way the criminal charge is established, if one person is in illegal possession of a firearm, they can arrest everyone. The staff explained that youth held as adults were held for approximately 150 days, and more than 75% of the charges were dismissed. Youth charged and held as adults in detention for more than 150 days for no reason. This is one example of the problem with the statute. The Supreme Court of Maryland has articulated the need to fix this problem in the case Lawrence versus Maryland. In light of these policy concerns, legislation ought to be considered to address the scope of CR 4203. And this bill does that. The bill applies the knowingly culpability standard to all offenses listed under the illegal possession statute. This change differentiates the person who has mistakenly violated Maryland's permit law from the person who has purposefully violates the statute. This bill removes the language "or about." This is known problematic language both in enforcement and in prosecution. The bill removes the rebuttable presumption that a person who transports a handgun violates the law knowingly. Such presumption is a clear violation of rights. Finally, the bill creates a monetary fine for first-time offenders who have simply violated our permitting laws. Folks who mistakenly violate permitting laws should not be prosecuted as if they were violent offenders. Our culpability laws should reflect that desire. For that reason, we should pass this bill. Happy to take questions, and I'd ask for a favorable on House Bill 354.
Thank you, Madam Chair. Mark Pennick again in support of this bill and enthusiastic support. The Maryland Supreme Court has asked this body explicitly in Lawrence versus State to fix 4-203. We quote the language in my written testimony. I have this pin sites here. You can read it for yourselves. It is a matter of good governance to do what the Maryland Supreme Court has asked you to do, because the constitutional issues associated with that are laid out in that decision. Not to do so, to ignore this, is simply to invite the Maryland Supreme Court to invalidate 4-203. It's not particularly smart. So I'm asking this body to at least address the issue that the Maryland Supreme Court has asked it to do so. And that is to strike the "or about" language out of the statute and impose a knowingly requirement, a mens rea requirement on the violation of the underlying statute. That knowing requirement is common to other parts of Maryland's firearms law. It is the requirement in all federal firearms law. It is as common as rain. It separates the culpable from the non-culpable, from the innocent from the non-innocent. And in Maryland, if you get arrested and somebody in the car has a gun, everybody gets arrested. Everybody sits in jail. And that's just wrong. It's also wrong to violate a failure to get a carry permit, which costs around $600 in this state, to be subject to a disqualifying offense for the rest of your life, when all they need to do to become a qualifying person is get a permit. So they have a constitutional right to carry, and it's exercised in this state by getting a permit. The failure to commit, it should not be penalized by 5 years in prison or by a permanent lifetime disqualification for ever getting a permit or ever exercising the Second Amendment right. So we are very much in favor of this bill, and as a matter of common sense and equity, you should issue a favorable report. Thank you.
Thank you. Mr. Joseph?
John Jocelyn for 2A Maryland. I concur with Mr. Pennick. Several years ago, the Maryland General Assembly increased the penalties for carrying a firearm without a permit. This was in response to the Bruin decision. History has shown that we didn't get the negative impact that everybody thought we would have. The law-abiding continued to be law-abiding. The criminals continued to be criminals. However, the increased penalty is, as Mr. Pennick noted, a lifetime prohibitor. For the simple wear and carry of a handgun, absent any criminal intent, absent any criminal activity, and absent any prohibition on the person carrying it. This is for a nonviolent, no impact on social offense. You can lose your constitutional rights for the rest of your life. There's some interesting things about the way the bills are written and the laws are written. Public Safety 5-303 says a person shall have a permit issued under this subtitle before the person carries, wears, or transports a handgun. Full stop, end of story. Blanket thing, you have to have a carry permit. This conflicts with 4-203 that gives you various locations to which you can transport your firearm, provided it's unloaded and not accessible, but still negated by the public safety article. I would point out there are many locations we hear about, for example, gun buybacks. Every person who goes to a gun buyback who does not have a carry permit, but who is carrying a handgun they want to turn in, is in violation of 5-303 and 4-203 and can lose their lifetime rights to carry or own a firearm. We can fix this, we should fix this, we ask for approval. Thank you.
Thank you, Mr. Jocelyn, and I apologize for mispronouncing your name a minute ago. Delegate Erican.
We have Ms. Brownlee.
Oh, yes, we do. Sorry, Ms. Brownlee.
Thank you. Good afternoon again. Once again, my name is Holly Brownlee, and I'm an assistant public defender on the Eastern Shore. The Maryland Office of the Public Defender respectfully requests that the committee issue a favorable report on this bill. This bill seeks to amend the existing laws regarding passive gun crimes involving wearing, carrying, or transporting firearms. By including a knowing element to 4203, this bill helps ensure that the law doesn't unintentionally criminalize, for example, mere passengers in a vehicle or who could only be guilty under principles of constructive possession. As a felony trial attorney in Maryland, I have represented and continue to represent persons charged under this law. Frankly, the majority of them were law-abiding citizens with no legal prohibitions on possessing firearms, and who at best were guilty of improper carry or improper transport, meaning they didn't have it in an appropriate case within the vehicle, or they had it without a carry permit, or in some instances just didn't have it unloaded. One client even had an HQL. Many of my clients have also been out-of-state carry permit holders who were simply driving through and didn't realize the complexity of our state's gun laws. Honestly, it breaks my heart when I see this happen, because in all of these cases, these persons are now facing a 5-year charge with a 30-day mandatory minimum penalty, albeit suspendable. And unless they obtain a probation before judgment, as has been noted, they have now lost their ability to possess a firearm forever. This bill would change that for certain categories of violations, specifically for persons who are simply passively wearing, carrying, or transporting the firearm on their person or in a vehicle, and who are not otherwise prohibited from possessing a firearm. There would be a $1,000 fine. For other categories, such as going on school property or having a firearm with an intent to injure or kill, or who have even just been convicted before under this statute, there would be jail penalties that would kick in. Quite simply, this bill would give many Marylanders a second chance to make sure they know the law and prevent inefficient use of judicial resources in penalizing persons who truly had no bad intent. The Office of the Public Defender respectfully urges the committee to issue a favorable report on this bill. Thank you.
Thank you. Now, Delegate Erican.
Thank you, Madam Chair. Thank you guys for being here. I just want to make sure I'm not like missing anything. So I pulled my card out to read what it actually says, and it does mention 5303. It says, yeah, I have to abide by 5303 and 4203. But you're telling me that I guess this question's for Mr. Jocelyn, that those two things are in conflict, and that there's like, you mentioned gun buybacks. Are there any other places or situations where somebody who's generally law-abiding, no criminal intent, could run afoul of the law?
Yes, on the issue of gun buybacks, which is an interesting thing because this law is on the books, and at every gun buyback, law enforcement is there. So they're not enforcing the law in this particular instance. But if you get stopped on the street or you get pulled over, you could be.
Okay.
There are exceptions in 4-203, provided the firearm is unloaded and it's carried unaccessible and its ammunition is separate. There are limited places where you can go to and from the dealer, to and from the range, to and from hunting, a shooting event, things like that. Gun buybacks are not one of those exceptions.
Okay.
So everybody who participates in that is actually violating the law. Okay. They don't know they are, but they still are.
Right, and there's currently no mens rea, so the fact that they don't know is irrelevant. They're still in trouble.
Yes, they're still in trouble.
Okay.
So if I may comment on that, Eric, and one of the exceptions in 4-203B is going back and forth to the range. But if you happen to stop on the way to go, say, leave the gun in the car and go shopping, or even to get out and pay gas, you're no longer transporting.
Oh, wow. So even if I'm running out of gas, I'm in trouble.
You are now an arguable in violation of 4-203A.
Oh, my gosh. And the penalty is what?
Is
for permit
5
loss?
years. 5 years.
Permit loss.
And at least an arrest record and up to the prosecutor then whether to prosecute.
Okay.
I mean, it got so bad in Baltimore that the then State's Attorney General was simply dropping the charges because there were so many unfair arrests under this bill.
Oh, wow. So they they're not prosecuting any, they don't even care if it's criminal or not. They're just.
Well, no, they would exercise discretion as to whether or not to bring the charge. But that's simply a matter of discretion of the prosecutor. They're still arrested, they still have the arrest record, they still have to face the jail time after being arrested.
Yeah, hire attorneys, things
You
like
have to
that.
hire the attorneys and go through the whole thing.
Okay, thank you, guys.
There's nothing fair about any of these results.
Yeah, that seems unreasonable. If two parts of the code are in conflict, I think that's an easy fix.
If I may, some years ago, a bill was offered to allow for reasonable stops for rest and refreshment as you travel. For example, if you're going to Garrett County, where I hunt quite often, I would stop in Hancock.
Right.
Absent a carry permit, if I stopped in Hancock for gas or for lunch, I'm in violation of the law.
Yeah, I have to stop every time I go to West Virginia because somewhere in there because I need to get gas. Okay, that's good to know. Thanks.
Great, thank you. Delegate Moon?
Thank you, Madam Chair. I can't speak to the juvenile situation you started your testimony with, but the part of the conversation I just want to follow is what the actual numbers look like on these offenses. And so I'm looking at the fiscal note here, and from at least what the analysts are saying, it looks like the numbers are something like you have 3,000 or 4,000 violations for various ones of the offenses that you're tagging here, but just a few dozen that are actually getting convicted. So it would also be fair to say, would it not, that the discretion is actually not being used to penalize the types of people you're talking about that harshly?
I can comment on that. I got a lot to say about that, actually. So first, Ms. Brownlee mentioned the person passing through. They didn't have a great understanding of the law. There's actually, the Baltimore Banner did a great piece. It's called A Complete Lie, what actually happened in a gun case cited by Baltimore State's Attorney Ivan Bates. And this was a guy from West Virginia. West Virginia, to keep it summarized, is a really different place. He was driving through Baltimore, and they really went after him. They were trying to put him away just because he had a gun in his car and got pulled over for some kind of traffic violation. I think that you should start by reading A Complete Lie. As far as the second thing that was mentioned, the juveniles, I would say that, I would remind you that the juveniles charged as adults didn't actually get charged, so they would likely not appear under the numbers you're looking at. But with that said, and you could look this up, those juveniles were detained for at least 150 days. So if we care about over-incarceration, we should think about those scenarios where we have juveniles detained for months, not charged, that aren't appearing in physical notes.
Madam Chair, can I actually ask the public defender on Zoom, this is just one of these things I've been trying to track through data over the years, what's actually going, because these claims are always made, what's actually going on the ground with gun possession. I mean, my vague sense of it is these cases are basically churned, unless there's something serious or some other offense mixed in there, that these are not people that are doing time, right? They're just picked up on a basic wear carry. Is that fair to say?
That's fair to say. They're certainly being prosecuted. I'm usually able to get a probation before judgment if it's not too heinous. I was able to beg and plead one time and get a stet for somebody who already had an HQL, but that's the level we're at. So
okay,
it's not necessarily the jail time. I think it's as has been said, it's unless you get that probation before judgment, I mean, that's it. You're done. You can't possess a firearm again.
Would you say that's different if for illegal possession and where the person wasn't qualified otherwise for a permit? Or are those cases also churned?
Right. So, I mean, I guess what we're talking about here is persons who otherwise are not legally prohibited. I've certainly had an array of cases where they're prohibited and they're also charged with the wearing and carrying. But for these people who, like, say a student at Salisbury University and they're traveling and it's basically improper transport, that's what we're talking about, and that's somebody who would be prosecuted at least on the Eastern Shore.
Yeah, I mean, I guess again, the thing I'm trying to understand is on the one hand, we see numbers and data that indicate gun possession doesn't appear to be a very serious charge at all in Maryland. People aren't doing time for it. I'm not seeing conviction numbers that show the courts are treating this as a serious infraction. And at least there'd be some segments of that population. It sounds like you're trying to draw some distinctions here, but that there are some segments that would warrant more attention. But again, just from where I sit, the numbers in the fiscal note and all the numbers I've looked at in the years in Maryland do not appear to show gun possession as a crime that's taken seriously by law enforcement. Just my perspective.
Sorry.
No, go ahead. Please.
I was going to say, if I may, Delegate, if anything, I think that speaks to this idea that person's charged under this law or convicted under this law, or they're not doing the jail time usually because it is looked at as a de minimis violation. And so if anything, this bill is just putting in line with what you're already seeing, which is that these are people that are not doing jail time. My clients that are doing the jail time, they're the ones that are the prohibited persons. And frankly, I think that's what people are generally more comfortable with penalizing, right? Is the persons who are already prohibited for various reasons and are still illegally possessing the firearms.
Got it. And I guess I just wanted this discussion on the public record because I think it's not quite understood how much we churn these cases. I think the public probably gets the impression that they're taken a little bit more seriously than they in fact are. Thank you.
Thank you.
Yes. First, I want to say what a special day this is because the public defender is supporting a bill from my friend from Essex, so that's a very special day. But my question is, the MSAA is opposed to this legislation. They say that your legislation trivializes the danger of somebody carrying a gun without a permit, and so I wondered if you had a response to that. My second question, if it's okay, Mr. Chair, is just serving with you for the past 3 years, you often lament crime in Baltimore County from the dais. And so I'm just wondering if you're at all worried that, because it seems to be what the state's attorney is inferring, that it'll increase the crime that you so often lament. So if you could answer those, that'd be
So I'd start by saying there are several charges that are germane to those issues. Conviction of a crime while possessing a firearm is the first and foremost. So we've got that covered. What I would say is both, the State's Attorneys Association, which is, I believe, who you quoted, and the Attorney General as well, are trivializing the over-incarceration of people who haven't committed any crime at all. And don't trust me, trust the Maryland Supreme Court, who has pointed out the nature of this problem. This is a strict liability crime, and not only can you be found guilty for just having it mistakenly, you can be guilty by proximity. So I think the people that we should think of are those young, overwhelmingly black young men who are sitting in Hickey for over 150 days for a crime they didn't even commit. So I think respectfully, I agree with the prosecutors a lot of time, but I think in this country, we don't arrest people for crimes that they had no part in playing.
Thank you, Mr. Chair. Delegate Tomlinson.
Thank you, Mr. Chair. I just had a question about, I think you may have touched on it earlier, the Office of the Attorney General, surprisingly, wrote a letter of opposition. They have a line here where they mention that they believe the bill would have a strong negative impact on current and future gun-related litigation by substantially increasing the difficulty of meeting the burden of proof. I don't know if you
say that one more time. I'm sorry.
Sorry. The bill would also have a strong negative impact on the current and future gun-related litigation by substantially increasing the difficulty of meeting the burden of proof.
So if I may respond to that, Delegate. Yes, it does change the statute from a strict liability statute into one requiring a knowing violation. That's the mens rea requirement that we find in other portions of Maryland law, gun law, and in all federal law. It separates the culpable from the non-culpable. So what the Office of the Attorney General is basically wanting to do is continue to impose strict liability of people who innocently possess or in a vehicle who happens to get pulled over and somebody in that vehicle has a firearm. And that's strict liability because, as the defender's office knows, constructive possession on everybody else, and they have to disprove because there's a presumption of guilt under this current code. So, yeah, I'm not sympathetic to the Attorney General's view on this because they shouldn't be prosecuting people who are innocent or not culpable of intent. That's just basic mens rea law. And that they insist upon doing that indicates the scope of discretion that the state Supreme Court in Lawrence versus State held was at the heart of the problem and asked the General Assembly to change it for that very reason, because it was a strict liability statute. So I encourage this committee to read what the Supreme Court said in Lawrence versus State about the role of mens rea and how important it is.
And the most egregious part of the bill, or the most egregious part of the statute, is the or about. Because what they're doing is they're finding situations where one person is in illegal possession. It's a transport situation, and they're just arresting everybody. And that is ridiculous. And the state's attorney should know it.
Thank you.
So, thank you. And you went right to where I think I wanted to go. What if would you consider just dealing with that issue?
Yes.
Right? And from a prosecutor's perspective, it presents a dilemma, right? I'm in a vehicle, the gun is under the seat, it's under the passenger seat, and the passenger says, I had no idea that gun was under the seat. How does the prosecution, how do prosecutors deal with that? Which is their issue, right? I mean, that's what they're saying. How to be able to get all 4 of the passengers that are in the vehicle because somebody knew.
Right. Well, the other 49 states have done this, and they've done it without creating criminal statute, which allows them to arrest people that had no part in the crime. So I think that's the best answer, and I've not found another state who's had a similar problem. And again, I point to the fact that our Supreme Court has pointed out this exact issue.
Thank you. Mr. Pinnock, you biting. Yeah, go ahead.
So just on that point, the state's attorney has the problem it has in every case, which is to prove by the circumstances presented in particular facts, possession is illegal under the law. But to arrest everybody in the car and throw them all on the slammer because somebody possessed it and nobody else knew is simply a question of proof. And that's always the state's burden, to prove beyond a reasonable doubt that the crime has been committed by this particular individual. I'm not sympathetic that they want to make it easy. And just as this body has made it easy with strict liability, that's precisely the problem that Lawrence said was the problem. Because on or about is so vague that nobody has notice. And it's a strict liability statute, so you don't, basically you're allowing prosecutions at the prosecutor's discretion. And, you know, I come from 33 years of the Department of Justice. I know all about prosecutorial discretion. It's not your friend. So you're basically putting people in peril and sitting in jail waiting trial until charges may be dropped or maybe not on something that you never had any part of. And that the prosecutor has that kind of discretion, it's just wrong.
If I may weigh in? From my perspective, I'm usually representing drivers, and frankly, I think drivers are in a lot of more of a different situation than mere passengers in a vehicle. And so frankly, I don't see the prosecution changing that much for drivers, but I think this can have a huge impact on those situations where you do have multiple people in the vehicle, and if someone's not owning up to it. I mean, I think the law, our case law does, in many instances, does show that if you're the driver, you're sort of presumed to know what's in your vehicle. I'm not saying that doesn't give me some ability to argue, well, they don't usually drive this car, or here was this unique situation, but I don't see how that changes the prosecution so much, specifically of drivers.
Delegate Eric.
Thank you, Mr. Chair. Sorry for the second bite, but I've just come up with a hypothetical, and I know Delegate Grammer and I have had many a debate over this exact bill and don't always agree on every detail of it, but now I want to know. Let's say my wear and carry permit has expired and I'm in the car with my 18-year-old who's driving and we're pulled over. Can she be charged?
Yes.
Great.
There is a strict liability, and there's also a rebuttable presumption.
Okay.
So it doesn't matter they're assumed to know and assumed to be guilty.
So she should just psychically know that my card has expired.
Therein lies the problem.
Yeah, okay, thank you.
Time for this. Any other questions? Seeing none, thank you all very much. That concludes the testimony for House Bill 354. Now we'll go to House Bill 361, please. Melissa Maloney, Ken Eaton, Beatrice Mania Diaz, Carolyn Gramis, and Felice Kelly.
I'll start when you're ready, Mr. Chair. Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 361. House Bill 361 requires that people charged with reckless or negligent driving, which results in the death of another, must appear in court. There are tragic cases in Maryland where families who have lost a loved one through reckless driving show up to court to face the driver who killed their loved one, only to arrive at hearing and find that the driver is not present. Also, because these cases are on a normal traffic docket, they can be erroneously dismissed for processing issues. It is long understood that it is important, that is an important part of our court system, that the families of victims have an opportunity to see justice served. If you lose a loved one due to reckless or negligent driving, there are situations where those families lose that ability. This bill rectifies the situation by specifying that those charged with reckless or negligent driving must appear in court and that they may not prepay the related fine. It also allows the court to waive this requirement for good cause. There are approximately 535 fatal crashes a year in Maryland. These cases appear on a normal traffic docket, and the state's attorney's office is not notified and thus not able to take the necessary steps to provide the families of victims the much-needed support. Additionally, without a must-appear citation, these types of cases can be dismissed without fault for processing issues not related to the case itself. This bill is named after Sherry Zidon and Christian Butcher, whose families were shattered when they lost their lives due to reckless and negligent driving. We can help these families see justice with this simple and appropriate technical change. Thanks for the opportunity to present House Bill 61. I'd be happy to take questions and ask for a favorable.
Hello, my name is Beatrice. Thank you for your time. I was heartbroken to discover that my family isn't alone in facing this injustice, the inability to confront the person who took our loved one away. It's devastating to realize that my brother's life was valued at just $1,000, allowing Mr. Savoy to walk free. Other families like Sherry and Christians also deserve the closure we've been denied. Writing this honors them. We all deserve. Thank you. My brother Jonathan worked part-time as a limo driver to support his children. On March 3rd, 2024, at 4 a.m., he was hit by a drunk driver. He did not even realize he had struck him. At the time of the accident, the driver was going 33 miles an hour, which enacted my brother to fly 22 feet from the impact. Jonathan lay lifeless on the ground and ultimately suffered severe injuries, including the loss of an eye and 22 skull fractures. Tragically, he succumbed to his injuries 2 days later. This loss has shattered my family. We are still searching for ways to heal. My mother has lost the will to carry on, and my nephews miss their father deeply. Witnessing my mother mourn my best friend has been haunting and exhausting. I can see the sadness in her eyes and the dullness in her tone. I'm also mourning my mother. She seems like a shell of her former self, merely going through the motions of life, and she will never be the person I once knew. I continue to hold on to fragments of memories of him as we navigate through this heartbreaking journey. All three of these families have lost someone dear, and we stand united against this injustice. I urge you to support the passage of this bill today. We cannot allow this tragedy to affect another family. It is time to enact the Sherry and Christian law to hold individuals accountable and prevent them from simply paying a fine to invade responsibility. Let's not allow another family to suffer this heartache. Thank you.
Thank you so much.
Good afternoon. My name is Melissa Maloney. I'm an Assistant State's Attorney in Hartford County. Thank you all for allowing us to speak here today. On February 28, 2024, the case of State of Maryland versus Elijah John Palm appeared in the Harford County District Court. The citations were speeding, failure to control speed to avoid a collision, failure to stop at a sign or a pavement marker, and negligent driving. Because these citations are payable only, they were scheduled on what we call the routine traffic docket. Unfortunately, Mr. Palm's driving caused the death of another individual. Despite the seriousness of the event, no one from the state's attorney's office was notified nor present. Assistant state's attorneys do not appear on routine traffic dockets. Additionally, the case was not prepared by our office, and thus the civilian witnesses necessary for the successful prosecution of the case were not summoned. Had the negligent citation been a must-appear citation, the case would have immediately defaulted to a serious traffic docket, and my office would have been notified. Thereafter, we would have reached out to the victim's family, summoned witnesses, and been present to treat the matter with the dignity and respect deserved whenever a life is taken. There's absolutely no scenario that I could imagine where an individual's speed that results in the death of another would not also garner a negligent driving citation in the very least. I can think of nothing more serious than a person's life being prematurely extinguished. By passing House Bill 361, the family of the deceased gets closure without placing any extra punishment or punitive measures on the defendant. Additionally, appearance in court allows the defendant to truly face the impact of their poor driving and serves the public interest of deterrence. Thank you very much. Yes.
Good afternoon, Chairman Clipperger, Vice Chair Bartlett, and members of the House Judiciary Committee. My name is Ken Eaton, and I am the Executive Director of A-Beta Maryland Incorporated, a state motorcycle rights organization. A-Beta's been working on bills of this type for many, many years. We worked on a right-of-way violation penalty bill from 2004 through 2008. In the middle of that effort, Marty Schultz, our Executive Director at the time, died in an accident where another driver violated his right-of-way and caused his death. In 2008, we were successful in passing the right-of-way bill, but after a few conversations with attorneys over the years, they told us the bill didn't have enough teeth, the law didn't cover it, it was being very rarely used. So now we're here with the must appear. This bill adds the must appear wording and includes the discretion of the court, which has been a concern over time. In my written testimony, I've attached a list of many of the current must-appear offenses with my testimony, and just as a quick glance, there's over 25 other things you can do and require must-appear, but killing someone in a traffic accident isn't on the list. I think it's past time to add this to the list. On behalf of the Schultz family, the Sherry Zidane family, the Travis Christian Butcher family, all motorcyclists, and all motorists in Maryland, I am urging support for HB 361, reckless and negligent driving penalties, and urge the committee to vote favorably.
So, Mr. Chair, Madam Vice Chair, members of the committee, I'm Felice Kelly. I'm an assistant state's attorney in Baltimore County. I have been prosecuting cases for 21 years, and for the last 5 years, I have exclusively prosecuted fatalities. In Baltimore County, there have been 19 fatalities that resulted in traffic citations in district court. In Baltimore County, we request that those matters be moved to a serious traffic docket. That is at the judge's discretion, and sometimes it's denied. 5 of the cases were prepaid guilties. An example that I have to give to you is the case of Patrick McCormley. Patrick McCormley was an assistant U.S. attorney here in Baltimore, or an assistant attorney general here. He was traveling on Mount Carmel Road. Another driver caused his death. The case resulted in payable traffic citations. It was set for trial on March the 10th. On March the 7th, his widow learned that the driver paid out the tickets. Another example is Joshua Burnett. He died on Dundalk Avenue. It resulted in traffic citations in district court. Those traffic tickets were paid out on January the 22nd. He actually has a twin brother The vehicle that he was operating was in his twin brother's name, and initially the police believed that it was the twin. Both the twin and his mom did not have an opportunity to provide victim impact to the person who took his life. As a prosecutor in Baltimore County with a serious number of these cases, I am urging favorable report on House Bill 361.
Thank you. My name is Carolyn Gramis. I'm sorry? Oh, really loud. I'm an assistant state's attorney here in Anne Arundel County, Maryland, and just like Ms. Kelly at the end, I exclusively prosecute manslaughter cases, but that also entails minor traffic cases where a fatality has occurred. One of the things I'd ask you to think about, as you've heard from the victims who are here, they don't have the opportunity to make a victim impact statement. In all other types of cases, they have the ability to address the court and to tell them what the impact has been. This precludes them from being able to make that statement. It is not asking to change the penalty. It is not asking to do anything that would change what the outcome is, but it gives them the opportunity to address the court, to let them be heard as to what the effect has been on their family and the devastation that it has caused. I don't call it closure, I call it closing the door sometimes, because it's not a closure because they keep going on with that grief. But part of this process is giving them the time that this mattered. This victim mattered. What happened to their loved one mattered. And by giving them the voice to be heard in court is really healing in some ways. It does not take away the pain, but to be able to be heard in that you have to already deal with telling a family that their loved one, it's a $1,000 fine is the maximum. That's if they don't pay it out. But to be able to say to them that you're going to have the opportunity to speak and to be able to address the court and to say, let me tell you what my loved one, let me tell you about them, and let me tell you what it has caused my family. And so I'd ask you to think of that aspect as well. And I am urging that you give a favorable report. Thank you.
Vice Chair.
Thank you, Mr. Chair, and thank you, Delegate Grammer, for bringing this bill. My question is for Ms. Gramis, because we like orange and we're both from Anne Arundel County. It seems to me that, well, how do we get to involuntary manslaughter? Is it because the police officer only has the tools of these crimes, these driving crimes? How do we get over to involuntary manslaughter?
I mean, it certainly goes to what the facts of the case are. I am shocked to hear, I don't know the story here, but to hear that there's alcohol involved and someone dying, to me, that automatically takes it to a manslaughter. It deals with the facts of the case. What is the actual behavior that is being done? If it is a simple negligence type of causation or of recklessness, it doesn't go to a reckless wanton disregard for human life. It doesn't get us into the manslaughter. And so there are times that does become the problem. We can't quite make it to a manslaughter charge, so it goes down to a reckless or a negligent driving. It's a common thing that we have to deal with in charging these cases that officers struggle with as well, to make sure that we have the requisite evidence to be able to elevate it to either criminally negligent manslaughter or to the negligent manslaughter.
Okay, thank you.
Delegate Card.
Much for coming in and all of your compelling testimonies. It's great to see our ABATE friends here in Judiciary. We don't often see you over here. For the prosecutors, I'm not sure who would be the right person to ask, but if you're on a must-appear docket, is there a state's attorney there? So always a state's attorney there?
Always.
Yes.
And the state's attorney will have the automatic right to be able to bring a victim up? It's not under the judge's discretion?
Yes, under the Victims' Rights Statute, they have an opportunity to provide a victim impact statement when there's a conviction on any count in a case.
Okay, but in a minor traffic where there's not a state's attorney, it's under the judge's discretion, and the judge could still always, he can always let somebody come up and speak, can't he, if he wants to?
Absolutely.
That's true. But the issue is when it's not on a must-appear docket.
Then they can pay it off, and so they won't even be there.
That's exactly right.
I got you.
Or it comes in, and the example that Ms. Maloney gave, the appropriate people weren't even summoned into court
Right.
because the prosecutor never had an opportunity to review the case.
And
The tickets were issued and it came up in court.
is there, presently in practice, there's just no information that's given to the state's attorney if it's charged as negligent driving?
If I might address that. So the incident I brought forth happened last year, right around this time. And our first instinct was to reach out to the District Court of Maryland and say, is there a way that these cases could be flagged when all it is minor traffic, speeding, negligent driving, nothing that carries incarceration. And today is the 5th of February, and I'm still awaiting a response for that. So that's why we approached it from this angle. Something to keep in mind is if you have an individual who doesn't pay a ticket and they get suspended on what we call driving while suspended H, just to pure that, all it doesn't carry any jail time, that is a must appear.
Right.
Yet in this case, someone dies and it's not.
So if the court alerted the state's attorney's office of these deaths in a negligent, if there was some way to flag it and let it, then you could have a state's attorney appear even at that minor traffic docket. Is that correct?
Yes.
Yes, or as Ms. Kelly indicated, they will often, and we would do the same, you file a motion to move it to the serious traffic docket.
Okay, so there are, if you got a timely, a prompt response, there may be another way of accomplishing this. I'm just trying to figure out in case for some reason this doesn't happen.
I understand what you're asking, and I understand your question in that if, in my county, and I know there's a lot of different counties that are here, it's a little different. Some are aware before they're even charged and some are not. It used to be that you would just get a call from a judge going, hey, I need a state's attorney to courtroom 1, which is the minor traffic. You'd walk in and you're like, how can I help? And you're handed a 25-page report saying, hey, could you handle this? And you're like, wait, what? So that's one way that it used to occur. If you had someone, if put in a reckless or a negligent and put it into the minor traffic docket, yes, you could still have someone come in, you could still have your victim there, but at any point, that could be paid out. Even the morning of court, I've had that. We're walking in, they see a state's attorney, the defense attorney hauls out and goes and pays it, and then we're done. And so that's really just to make sure we're not going through that process.
Got it. Thank you. Thank you, Mr. Chair.
Delegate Valentine.
Thank you, Mr. Chair. And I believe, excuse me, thank you, Delegate, for this bill, as well as the entire panel. And my heart goes out to some of your witnesses. I believe some of my questions have been answered in kind of the last 2 questions. Just to get to the point of, if we're on a must-appear docket, okay, your office or offices would be notified. And I don't know, this would only be in these cases, so maybe like in traffic tickets now, where you see contributing to accidents, I know in years ago, so there would just be a link that it would only be a must appear if it did result in death. So that's what you're looking for in this scenario, correct? Just so I'm aware of that?
Yes.
That's what you're looking, okay. All right, thank you.
The Vice Chair is going to be back.
Thank you. But in that scenario, unfortunately, in the case where this young lady next to the delegate said that the death was later, not actually at the scene, how would that work?
So delayed deaths can present some challenges. It depends on whether a traffic tickets are issued the night of the incident. Sometimes that occurs. Sometimes you have to get rid of those waiting for an investigation. So that's one way that it happens. That is an issue that you would not be able to address if you issued the citations on the night of the incident. I would hope that if once someone died a couple days later, that would trigger them to say, hey, we've got to fix this, and reach out to the state's attorney's office so that those could either be amended to include that, which we could do, or they could be null prossed and then reissued with the appropriate notation as to a fatal.
And who would do that, the officer or the family?
Yes, if the state's attorney's office is not aware of it, we would not be able to do that. It would rely on the officer taking that initiative.
Okay. Thank you. I'm sorry for your loss, everyone.
I have a question for the state's attorneys. When someone dies as a result of a traffic accident, is one of those calls right after that happens to the state's attorney's office?
Depends on which county.
Okay, so
I
there,
will say in Anne Arundel County, that is my sole function. I go to scenes. So I am usually aware of any fatal crashes that occur in this county or serious injuries. But that is not across the state.
but there is a, and I think this is starting to wander a little, my questions are going to wander a little bit from the scope of the bill, and I'm not going to go very far away. But the broader question is there is a choice that some states' attorneys' offices are making then, that they are not one of the first people who are called when someone dies as a result of a traffic accident. Is that correct?
My experience is, yes, that is correct.
Okay, so I guess there's a question in my mind that the argument was put forward that people don't know what's happening and when. It seems like there is this issue of communication that needs to happen across the state with state's attorneys' offices, not apparently in Anne Arundel County, but in other places where they need to find out, they need to share that information so that in those most serious cases, perhaps they could be adequately charged. Is that correct?
If you would like my opinion, yes, I do believe that, because I do believe that many offices that are smaller than Anne Arundel don't have someone that is dedicated as Ms. Kelly and I'm not sure if that's your soul, but that it is harder, and they are so technical that they don't have people who understand fatal crashes, and so it becomes an issue. So I can see where that is a problem in other counties.
But, Mr. Chair, that doesn't, having a dedicated prosecutor or that being the first call doesn't stop the ticket from being paid
There is the
out.
ticket, the payable ticket issue is still there. I just wanted to address the issue specific to notification, and so that somebody knows that this has happened, so that it could potentially at least get someone's attention to know that it's happened. That's the part of this that I'm a little hung up on. And again, it's not directly on the bill, but it does have, it is part of the stories that come out from the bill. And I see that there are 3 big-ish counties, state's attorney's offices here, and so I'm just pointing that out. All right, are there further questions? Seeing none, thank you very much. That concludes the testimony on House Bill 361. We'll go now to House Bill 394. Delegate Grammer.
Thank you, Mr. Chair. I believe there's at least one other favorable.
I'm sorry?
There were a couple folks in favorable. I'd welcome to the panel.
I don't have anybody else who is testifying orally. Is this in 361?
Oh, sorry.
Oh, you're on the next bill?
Yeah,
You're
sorry.
okay, that's fine, all right. Yes, sorry, yes. Jonathan Alexandra and Peggy Cairns should be, yes, all right, that's fine.
I'll get started with your permission.
Please, go ahead, 3 minutes.
Thank you, Mr. Chair, Madam Vice Chair, members of the committee. For the record, Delegate Robin Grammer to present House Bill 394. House Bill 394 requires age verification for online distribution of pornographic material and puts in place civil liability. Pornography alters the brain, no matter the age of the viewer. We humans engage in activity. Our brains create what are known as neural pathways. The more we engage in an activity, the stronger the pathway associated with the activity. The use of pornography creates pathways that detract from normal brain activity and normal human participation. Pornography also stimulates the release of dopamine, a neurotransmitter that allows us to feel pleasure. When engaging with pornography, the brain is overwhelmed with unnaturally high dopamine levels. This can alter the brain's reward circuitry and impact its natural ability to produce that feel-good neurotransmitter. Long-term outcomes of these changes to the human brain can have huge negative impacts. Porn use negatively impacts mood and personality, contributing to feelings of isolation, depression, and anxiety. Porn use is also known to create sexual dysfunction and sever the drive for sex with an actual real partner. Children and adolescents are particularly susceptible to this because of what is taking place during that stage of brain development. That is why we need to limit the accessibility of pornography for minors. The Pew Research Center reports that the U.S. household growth over the last decade was the lowest ever recorded. There are similar precipitous drops in young adults engaging in sex. Pornography use contributes to these grim economic figures. House Bill 394 attempts to fix this issue by requiring age verification on distribution sites of online pornography and placing civil liability for commercial entities that knowingly and intentionally violate the requirement. We can protect our youth by placing the same protections we use for brick and mortar retailers on online distributors. Thanks for the opportunity to present House Bill 394. Be happy to take questions, and I'd ask for a favorable.
Members of the committee, my name is Jonathan Alexander. I'm an attorney and legislative counsel for the Maryland Family Institute, in strong support of the primary objective of House Bill 394, which is to protect children and minors from harmful, obscene materials, even those that are distributed online, by requiring age verification methods. As demonstrated in this area of Maryland code, it is the longstanding commitment of this state to already regulate sexually explicit and obscene content in order to safeguard children's well-being. Importantly, this proposed law will not infringe on core First Amendment protections. It addresses materials that fall outside of its purview. Courts have consistently already held that obscene content can be regulated. It can even be prohibited. History establishes that the laws preventing the dissemination of obscene content, especially to minors, are constitutional. You know, as stated, children are at heightened risk due to the accessibility of explicit materials on smartphones and the internet. Statistics say that over 84% of males, over 54% of females aged 14 to 18 have encountered explicit materials online, and that exposure to pornography can affect their developing minds in a way that is similar to illegal drugs. You know, these age verification systems, they don't compromise privacy. It doesn't keep any personal data. It doesn't pose any security threats. If a commercial entity fails to prevent minors from accessing obscene content or improperly retains identifying information, there are ways for that damaged party to be able to get a reward for that harm. House Bill 394 strikes an appropriate balance between protecting children, respecting privacy, ensuring that First Amendment concerns are not impacted. With the explosive growth of online pornography, in order to safeguard the health and innocence of young Marylanders, we ask that you give House Bill 394 a favorable report.
Peggy Cairns, please, for 2 minutes.
Thank you, Chairman Clippinger and members of the committee, and thank you, Delegate Grammer and co-sponsors for the bill. My name is Peggy Cairns. I'm with the Maryland Coalition Against Pornography as its education chairperson. I'm a retired law librarian and a mother of 2 and a grandmother of 2. You have my written testimony, and you will see in it a link to an article worth your reading about the rationale for age verification measures. Texas is one of many states that are implementing these measures, and their case is before the Supreme Court now, and I believe that it will be passing constitutional muster. So why not Maryland? Why should our state lag behind other states in protecting our children? Why should we be seen as being in favor of allowing underage youth access to obscenity? Cigarettes and alcohol are rightly regulated because they are harmful. Do we not see access to online obscenity also as harmful to minors? It's providing extremely lascivious, often violent sex education to our youth. It is sexualizing the children, it's grooming them and exploiting them. What they are imitating is resulting in child-on-child sex abuse. Babysitters are doing it to their wards. Siblings and cousins are doing it to their respective siblings and cousins. Kids need better guardrails. Existing controls and filters are failing them. They are more savvy than their parents, and it is in society's interest to help families out with non-obtrusive measures like age verification. Please help these vulnerable ones, and please report favorably on this bill. Thank you.
Vice Chair.
So I've gotten a lot of my questions through testimony, but I was wondering if you had in mind either Delegate Grammer or the attorney who's with you, I'm sorry, I didn't get your last name, but as to how one goes about, because that was the first thing that came to mind. And I was wondering, are you gonna make people upload like a driver's license or something? Because just checking that box that I'm older than 18, you know, that's not,
So there are several platforms for age verification developed by kind of the technical groups, one in the US and one in the UK. So the standards are there. What's happened practically as these laws have moved forward in states around the country is that rather than trying to attempt to implement them, the providers of the sites just turn off the site. So while I wish I had a more practical answer for how that works, all I could say is the technology is there in several formats, but the producers have just opted out of the state altogether as a practical reality of the law in that state.
okay.
If I can add to that, there are several technologies that are creative in that way, and so a picture is not necessarily needed. There are hand gestures that could be made. Voice recognition is another way that AI is able to discern the age of the individual. So there's facial structure, voice recognition, many different technologies. And to place a bill like this in context, think of a brick and mortar facility where an individual has to present a card for a number of reasons, tobacco, alcohol use. There's a judgment from a human that says, well, this person appears to be underage. When they're presented with their ID, there's much more information on that ID that individual can retain. They can see their eye color, their height, their weight, their address. None of those things are required on these age verification websites. There are minimal information that allow the individual just to present some evidence of their age.
Oh,
Yeah.
Lord.
It's always a flattering occurrence when someone asks you. That's great.
Had to.
Thank you, Mr. Chair. My question has to do with the definition of obscene. And, you know, when I was younger, even Cartoon Network, you know, if you're on past a certain time, and even if it's 6 o'clock, I mean, there's things on there that I consider obscene. I know that you referred to in your bill the definition of obscene that's in the code, but tell me, you know, what is obscene? Like, or give me the Maryland definition, or what's our benchmark for that?
There are a couple of standards that the Supreme Court has weighed. The most through-line standard is you know it when you see it. So the technical way of understanding it is if it appeals to the prurient interest, there's no really other redeemable factor other than agitating the person in that sense. But a through-line way to communicate it is that you know it when you see it. To place this in context and to place the websites that have decided not to continue their services because they couldn't prevent minors from getting on. Pornhub is one of them. They've exited 17 states as a result of a law like this. The #1 search item on Pornhub was choking. So sexual explicit material involving choking. That's the level that a law like this seeks to address and prevent.
Yeah, and very briefly, if you look at the definition of obscene, which is referred to in 11203 of the criminal law article, that statute, which is in multiple places in our code, is based on the case law. The previous legislatures have really bound our statutory definition of obscene to what case law has played out in regard to this scheme of policy.
Got it, and it's not obscenities with regard to language, or this is...
No, it's very much in the structured in the contemporary community standards, would be patently offensive prevailing standards, et cetera, et cetera.
And I'll just say quickly, the best comparison, we're dealing with the internet, we're dealing with smartphones, best comparison is that store in, you know, the corner of town, in that seedy area of town that folks used to walk in and out, whatever material is in there. And the law is narrowly tailored enough to say if that website has a majority of that content on there, then and that's when that website falls underneath. So it's really narrowly tailored to address the specific explicit content that has been shown, demonstrated to be very harmful for children.
Thank you.
Thank you.
Chair, and thank you, Delegate, for bringing the bill. My question is for Mr. Jonathan Alexander. Have you worked on legislation in other jurisdictions, other states, and how has that gone?
Yeah, so the 17 other states that have eliminated Pornhub and other websites that just couldn't pass the muster, they've seen a lot of successes, and much of the deliberation has been around, well, is this protected First Amendment speech? This sort of regulation always overcomes that litmus test. Obscenities falls outside of First Amendment purview, and so it's passed the First Amendment constitutional litmus test. It's not content-based. It just has to deal with age verification, discerning if this individual is of the proper age of majority to engage in something that we determine is harmful for that child to consume, to view, if they aren't at the mature enough level to process it. So it's seen great success all around the country where it's been introduced.
Yeah, I appreciate the work.
Germane to that, the tech community came to us between last year's bill and this year's bill. So the language you're looking at is actually language that's been implemented in other states to kind of adhere to the federal way to handle this problem.
Okay, thank you. I appreciate all your work. Thank you.
Certainly, sir.
Seeing no further questions, thank you all very much. That concludes the testimony on House Bill 394. That concludes the bill hearings for today in the House Judiciary Committee. We're going to be back tomorrow at 1 o'clock.